Donald Trump has already indicted James Comey and Letitia James. Now reporting suggests John Bolton could face charges as soon as next week. Why are career prosecutors lowering the bar? And what does that mean for the rule of law? We're watching the playbook unfold in real time. 2 indictments down, a third reportedly on deck. According to recent reporting, former National Security Advisor John Bolton may be the next target in what appears to be a pattern of politically motivated prosecutions ordered by President Trump. This comes after federal charges were filed against former FBI Director James Comey and New York Attorney General Letitia James, both vocal critics of the former and current president. The warning signs were there. Bolton's home was raided weeks ago. Trump has publicly identified Bolton as a political enemy, and now sources say an indictment could come as soon as next week. Here's the question that should worry every American. When does a string of coincidences become a documented pattern? Let's lay out what we know. These cases span multiple jurisdictions: Virginia, New York, Maryland. On the surface, they look unrelated. Mortgage fraud allegations here, classified documents there. But zoom out, and the common thread is unmistakable. Every target has criticized or investigated Donald Trump. Legal experts point to a text message Trump sent to Attorney General Pam Bondi, accidentally posted publicly on Truth Social, in which he named individuals whose failure to be indicted was, in his words, hurting their reputation. That list included Comey, James, and a Democratic senator. This isn't speculation. It's documented. Why does this matter to you? Because the criminal justice system is supposed to operate independent of political revenge. When prosecutors become enforcers of personal grudges, no one is safe. Not whistleblowers, not oversight officials, not you if you ever find yourself on the wrong side of power. The standard for federal prosecution used to be clear. Career prosecutors were required to have a good faith belief that evidence existed beyond a reasonable doubt to secure a conviction. That's the bar, not some factual merit, not a scintilla of evidence. Beyond a reasonable doubt. According to MSNBC reporting, career prosecutors in Maryland reportedly believe charges against Bolton have some factual merit. That's the new standard. That's how far the guardrails have shifted. Compare that to the Comey case. Prosecutors in Virginia initially resisted bringing charges. A grand jury rejected some of the proposed counts. Yet the indictment moved forward anyway. In the James case, legal observers have called the charges legally dubious at best, and still, they proceeded. Here's what we're seeing. The Overton window of acceptable prosecution is being dragged into authoritarian territory. First it was, we'll indict even if the case is weak, because eventually they'll be acquitted. Now it's, if there's anything resembling a fact, that's enough. That's not justice, that's intimidation. Let's talk about the judges. You might assume they're sawing the wood in front of them, evaluating each case in isolation. And traditionally, that's been the approach. Judges weren't supposed to look sideways at other prosecutions. They weren't supposed to consider motive or pattern. But we don't live in traditional times. In the troop deployment cases, Chicago, Portland, Los Angeles, we've seen judges start to connect the dots. Judge Perry in Chicago explicitly cited Judge Immergut's ruling in Portland when she blocked Trump's illegal troop deployment. These judges are recognizing that atmospheric context matters. Even without formal legal precedent, the pattern is too glaring to ignore. Should the same logic apply to these criminal prosecutions? Here's the argument for yes. We've gone years, sometimes decades, without credible nationwide claims of selective or vindictive prosecution. Now they're cropping up in courthouse after courthouse. Different defendants, different charges, same pattern. John Bolton and an immigration case defendant in California don't have much in common, except both involve people Trump perceives as threats to his reputation. Democratic Congresswoman LaMonica McIver was indicted after conducting oversight of ICE facilities. That case is now under review for selective prosecution. The legal term is presumption of regularity. It means courts traditionally assume the government is acting in good faith. But what happens when the government's own statements betray that presumption? The Department of Justice is now arguing in court that statements made by its lawyers in one case shouldn't be held against them in another. Think about that. They're asking judges not to believe them when they contradict themselves. They're saying, under pressure, lawyers say things, don't hold us to it. When did truth to the court become optional? Now, let's address the counterargument. Some will say these are separate cases, brought by different prosecutors in different districts. Each rises or falls on its own facts. To treat them as connected would be to engage in conspiracy thinking. Fair point. Let's test it. If these cases were truly independent, we'd expect randomness. We'd see Trump allies indicted at the same rate as Trump critics. We'd see whistleblowers protected, not prosecuted. We'd see the Justice Department defending its actions with consistent legal standards, not shifting justifications depending on the courtroom. None of that is happening. Instead, we have a president who posts hit lists, an attorney general who, by credible accounts, has personally appeared in grand jury proceedings twice, once for Comey, once for James, and career prosecutors who are quietly accepting a lower standard for charges as long as it's not entirely fabricated. Here's the other argument you'll hear. These prosecutors are trapped. They have mortgages, kids in daycare, a terrible legal job market. Resigning on principle sounds noble, but it's not realistic in this economy. There's truth in that. Empathy matters, but empathy has limits. We're not in March anymore. These prosecutors have had months to find other work. And more importantly, their continued presence lends legitimacy to an illegitimate process. When career staff stay and comply, they allow authoritarian leaders to claim the system still works. If you're a line prosecutor who disagrees with what's happening, but you stay quiet at your desk, hoping not to get called on, you're part of the problem. Either follow your oath and resist, or get out. Because every day you stay and say nothing, you make it easier for the next abuse. This is about more than individuals. It's about institutional rot. Paul Weiss, a major law firm, has faced months of criticism for its complicity. Partners privately say they're looking for exits, but here we are in October, and the firm remains fully staffed. At some point, "I'm looking" becomes an excuse, not a plan. The same applies to prosecutors. If you're still working at the Eastern District of Virginia or Maryland, and you know these cases are wrong, you don't get to hide behind economic hardship indefinitely. You're a lawyer. You have options. Use them. What happens next? If the Bolton indictment proceeds, it will test whether judges are willing to apply the same pattern recognition they've used in the troop deployment cases. Will they see the through line? Will they demand that prosecutors meet the actual standard for charges, not the new, degraded one? We'll know soon. Legal observers expect movement within the week, and here's what you can do. First, pay attention to which judges cite other cases. When Judge Perry invoked Judge Immergut, it signaled judicial awareness of a broader pattern. Watch for that in the criminal cases. Second, ask your representatives where they stand, not vague statements about respecting the legal process. Specific questions. Do you believe these prosecutions are selective? Will you demand accountability from the Justice Department? Will you support legislation to protect whistleblowers and oversight officials? Third, support independent legal journalism and organizations that track these abuses. Democracy Docket, founded by attorney Mark Elias, is one of the most rigorous sources for voting rights and rule of law coverage. The link is available Subscribing is free. Do it. Fourth, don't normalize this. Every time someone says both sides prosecute their enemies, push back. No, both sides do not. What we're seeing now is categorically different in scale, coordination, and shamelessness. Let's close the loop. At the start, I asked when coincidences become a pattern. The answer is when the person in charge tells you it's a pattern. Trump posted the names. Bondi appeared in the grand jury. The standard dropped from beyond a reasonable doubt to some factual merit. They're not hiding it. We just have to believe them. John Bolton may be next, but he won't be last. Not unless judges start connecting dots, prosecutors start resigning, and citizens start demanding that the rule of law means something more than the rule of Trump's enemies list. This is about whether the criminal justice system serves justice or serves one man's vendettas. If this breakdown helped you see the stakes more clearly, subscribe for more fact-first, no BS analysis of what's happening to our democracy.
If you enjoyed the video, hit the subscribe button and turn on notifications so you don't miss any new videos.